Hello guys, welcome back to the video updates. It's Sade. Today's video is going to cover a little bit more in depth about the things that the court would look at whenever you file a lawsuit to try to do a partition of real estate, which is really a lawsuit to try to force sale or buy out with real estate. So in what scenario do people tend to file these types of lawsuits? Well, people file this type of lawsuit if they co-own property with other heirs, or if they co-own property with somebody else that they were friends with at some point, or maybe an ex. And the reason why with the exes, if you're not married, that you have to use this type of lawsuit is because you don't have the benefit of divorce court. Let's say you had been married and then there was a divorce, then the property issues and the ownership and debt obligation and things like that would all be determined within the context of the divorce. But this typically happens when people are not married, or if they were just friends, or they co-owned with a relative just because they inherited together, accidentally. So what are the things that the court would look at when you file this type of lawsuit, and how do you even get there in the first place? The way that people get here in the first place is that they've been talking to the other party or other parties, asking the other party to allow them to sell the property, and the other party has not responded at all or has said no. And they've made reasonable offers to buy the other party's interest out. Maybe they have cash to purchase that interest, or maybe they're willing to get a loan to buy that interest, but the other side is still being very unreasonable or doesn't agree with the numbers as far as the settlement offer goes. So that's typically the scenario in which people are forced to go to court, because they come to somebody like me. They go to a lawyer that's a real estate lawyer, and the lawyer says, listen, we do have to file a lawsuit to get this resolved because we've tried everything else. So you do file this type of lawsuit, and then the court will look at certain things. It seems to me like it will be pretty simple math, right? But of course, nothing in this life is going to be simple, because human emotions are involved, and also because there are other facts that play into the scenarios. The simple math that I'm referring to is the fact that you really only can split whatever equity is in the home, right? Whatever equity is in the real estate. It's a matter of numbers when it comes to equity, and yet those numbers could fluctuate significantly depending on what type of evidence you bring. So the court would look at the appraised value of the property. Current market value would be best off determined by an appraisal report from a professional. So your lawyer would ask you to get an appraisal through a licensed professional, and that will be used in court to determine the market value of the property currently. And then the other thing that you would need is the payoff quote from the lender if there's a mortgage on that property. So the payoff quote will be as of a certain date, and then you have the per diem, which is the amount that you add every day going forward from that payoff date to get the actual number once you reach the time of final judgment. Okay, those are the two things that will determine how much equity is in the home, because you can subtract the payoff quote, which will pay off the loan, from the appraised value and get a guesstimate, a really good guesstimate of how much equity is in the home. That equity is then what the co-owners will split according to their percent ownership, right? According to their percentage ownership interests. So when it comes to two people co-owning together, it's presumed that you're going to be 50-50 owners unless you have some sort of indication inside the deed document that says otherwise, or if you have an agreement that's a valid, solid contract that says otherwise. But the deed document itself is going to be the conclusive document. So you better be in there, or you're going to be out of luck. It's going to be very difficult. But you do have the opportunity of having a side agreement that says, person A brought this much money for the down payment, so that person A would always be entitled to a credit for the down payment in the future, no matter what happens. So that is a valid agreement. But if you wanted me to have 30% ownership interest while you have 70% ownership interest, then that document should be, the deed document should be the one that would state that. So that's the conclusive one there. So those are the numbers that I said seem pretty straightforward, because once you have the equity, then you can figure out how much is supposed to go to person A and how much is supposed to go to person and how much is supposed to go to person B. But of course, there are things that would affect those numbers, because typically when we have these types of lawsuits, one of the parties has stopped helping with the mortgage payments, maybe out of spite because they're upset, they're not happy with you anymore, so they stop making the mortgage payments, or maybe they just don't have the money to make the mortgage payments, and they know that you are the more responsible one, or you have more money available to you. And of course, you're making the mortgage payments because you don't want negative reporting on your credit report, and you also don't want a foreclosure. So once you've done that for a few years, that means you're entitled to credit for all the missed mortgage payments that the other person missed for their portion of the mortgage. Those will be credited to you and taken out of the other person's share of the equity, naturally so. So that you should be able to get back the credit for the mortgage payments that were missed. And the courts also allow you to get credit back, of course, for the property taxes that you paid, that the other person was supposed to pay as far as their share goes. And then of course you also get payments back for any types of interest on top of all those things, if there's private mortgage insurance on there as well, and also the homeowner's insurance. So those are the main things that the state law here in Texas would allow you to get credits for, and we call them offsets. So you get the offsets towards the equity that the other person would normally have received. So in a scenario where we've done the math, and let's say the property appraises for $300,000, and then there's a payoff quote from the lender, and the payoff quote is for $50,000. That means there is $250,000 potentially in equity in that home, right? And so normally you both will get to split that $125,000 a piece. But because the other person had not made mortgage payments or property tax payments or insurance payments or anything at all for a few years, you get the benefit of getting payments for half of all those payments that you made, because you're half and half owners. So you get credit as an offset towards their portion of the equity. So let's say that you already paid about $25,000 for all those things, and the other person was supposed to pay half of the $25,000, then you get credit for $12,500 out of the person's share of the equity. And the other things that you could get credit for would be necessary repairs for upkeep of the property. And those things are open to interpretation, but of course if you have solid evidence to show that the repairs were necessary, such as roof replacements and things that are deductibles towards the insurance claims that you made for damage to the property, then of course you would be able to get a credit for that as well. You don't get credit for every single thing, but you do get credit for things like that. If you made upgrades to the property that significantly increased the market value of the property, you don't get to double dip. So meaning that the upgrade has already been reflected in the appraised value of the property, and so you get to split the equity half and half regardless, even though you were the one that made the upgrades, because those are seen as optional things. Those are things that you decided to do on your own, although the other person is getting the benefit of it by having the equity go up because of the appreciation and value because of the upgrades that you made. So if you have a lawyer that could argue it, sometimes you're able to get, you know, half of the amount of those upgrades if you kept good receipts, and you can show that you were doing remodeling which was needed, but you went a little bit above and beyond to make it really nice, and then you might be able to get half of the costs also as an offset towards the credits that you get, right, from the other person's share of the equity. If there were tenants living in the home that you rented to while all of this was going on, and the other person knows about it or asks you in the discovery phase, which is the phase in which lawyers ask questions back and forth, and they find out that you did have tenants in there and the tenants were paying you, then they get credit for half of all the rental income that you got all those years. So it could go either way. You could get credits on both sides, but those are the things that the court would look at before arriving at the final numbers. And so when you file this type of lawsuit, it's not necessarily to force the sale of the property, because usually you want to keep the property. You're just interested in having your name only on the title. So in order to do that, you would make an offer to the other side even while the lawsuit is going on. You'll make an offer to the other side even while the lawsuit is going on. Once the numbers have been determined, you make an offer that you would like to refinance, and you'll be able to pay the other person X amount, whatever that number is that was determined as part of the lawsuit. So you make the offer, and if they still say no, then that means the court would potentially force sale. But of course, you can be the buyer because you already know that there's going to be a sale. So if you bring a reasonable amount and you have two real estate professionals that agree that the amount that you're offering for purchase of the property is a fair market value, it's the right amount, then the judge would have no problem selling it to you. So you still get your end result that's the same. It's just that it took a long and roundabout way to get there because you had a difficult opposing party. And that's typically because people have bad blood. And it's typically because people have a lot of bad blood between them, and they have history, not good history, and the other person is being spiteful, unfortunately. So those are the things that the court will look at. Hopefully this video has been helpful to you. It's for educational purposes only. If you have specific questions about your situation, you should always consult with a lawyer. And of course, if you're in another state, the laws might be slightly different. So always consult with a lawyer regardless, so you know your best options. If you haven't yet done a thing like this, like buying a piece of property with somebody else that you're not sure about, or somebody else that it seems like a good idea at the moment, really think about it. And if you want to protect your interest, you can have a side agreement that says how things will be divided if there's a falling out. You can actually have a contract like that, and I think it will be able to hold up in court. So if you have something very definitive that talks about how you would handle things if there's ever a need to separate. So you should have that in place if you want to protect yourself, if you must buy property with somebody that you're not married to. Your assignment really in getting ready for a lawsuit like this is to gather all the documents for your mortgage payments, gather all the documents for your property tax payments, your homeowner's insurance policy premium payments, as well as any major repairs that you made to the property and money that you had to pay out of pocket towards any kind of damages to the property, and maybe your upgrades that you made to the property as well. The other things that you want to ask for will be the mortgage payments that the other person missed, of course, and that all will be shown by all the documentation that you have. And you will get an appraisal report closer to the time of the lawsuit itself, so that it's close enough in value. In order for you to get to this stage, you've already made the person an offer and they've said no. In order to make your offer look more reasonable, I think it's fair for you to get a CMA or comparative market analysis done by a realtor, or broker price opinion from a realtor, because if something is coming from you and the other person doesn't like you, they already are suspicious of you. They don't want to hear anything that comes from you. But if it comes from a real estate professional, they might actually examine it. And so that would show them that you are being fair, and that is the current market value of the property most likely. And then you also get a payoff quote from the lender if there's a mortgage on that property, to show them the equity in there. So the difference between the broker's price opinion or CMA and the payoff quote would be the estimated equity. So if you make an offer to the other person of half of that amount, and then show them why you need to get credit for all the missed payments and everything, I think that would make your offer more solid, because once they consult with a lawyer of their own choosing, the lawyer would let them know that offer looks reasonable. Now, if they want to blow you off after that, then that's up to them, right? So you would have done your part to line everything up to see if you could sort it out without a lawsuit. So those are the things you should definitely put together to show the person that you are making a reasonable offer. The other thing that you want to put together is a timeline for refinance to remove the other person's name from the loan obligation if there's a mortgage on there. So talk to lenders before you make an offer, so that you can confidently tell the other person that I will be able to refinance and pay you your share of the equity, or refinance to remove your name, whatever the case may be, within X amount of weeks. That makes people feel better. It makes them have a clear view of what exactly you have in mind. So those are my suggestions for you. Hopefully this video has been helpful. And if you haven't yet subscribed and you like the channel, make sure to subscribe today. And I look forward to making more videos and seeing you guys next time. Thank you.